Hi, everybody. I am so excited to have you join us today, and what a day it is. So, listen, we are getting an overwhelming number of emails, phone calls, messages, even on Facebook for doctors and business owners wanting to know, hey, what are all these changes and do they apply to me? And so I have never been so incredibly thankful for the wonderful friends that we have in chiropractic, like Dr. Steve Conway, who, man, did he deliver on this issue when he introduced us to his amazing friends who are going to address those questions for you today. So before we get started, this webinar is being recorded. You do not have to ask for a copy of the recording because I cross my heart, it is being sent to you 2 hours from now. 2 hours. You'll be able to log in, go back and watch it because this is a lot of information that we're going to go over in an hour. You do not have to ask for handouts. They're going to pop up under files as things are being discussed. So again, just click on it. It'll allow you to download those. They're available. So guys, even if you're watching this recording, just remember you can access those as well. If you have questions, submit them throughout the broadcast. We're going to try to answer as many as possible, but please understand there is one of me, one Dr. Conway, 3 amazing attorneys, well, 4, because Dr. Conway also an attorney, and we're going to answer as many of those as possible, but we're going to send you an FAQ and try to answer whatever we can't get to after this webinar today. So whether you're watching the recording or live, everybody will have access to that. So without further ado, welcome Dr. Steve Conway.
Thank you, Christy. Welcome everyone to this important webinar on the new employment laws that will now affect small businesses with fewer than 50 employees, which I am sure is everyone listening on this call. In the past, small businesses, such as all of our chiropractic offices, were exempt from these laws, but on March 18th, 2020, President Trump signed into law the Families First Coronavirus Response Act that removed many of these exemptions. These new laws go into effect on April 2nd. So I'm the Executive Director of the Chiropractic Society of Wisconsin, or CSW, and will be assisting with the program here today as the moderator. And I'm going to try and work, like when all these questions come in, we're going to try and put them in with the most questions asked and have the response or the attorneys answer those while we're here online. I'd also like to extend our gratitude to Dr. Ray Foxworth, Christy, and the amazing team at ChiroHealthUSA for hosting this webinar on their platform. This webinar was initially created for our members, and we really quickly realized that our capacity wasn't going to be able to handle the interest. So I called up Dr. Foxworth for help, and he and Christy agreed to help with this whole program. So please know that our members and chiropractors across the whole United States appreciate ChiroHealthUSA and your continued support through these educational programs for our entire profession. So thank you. Today, we're very fortunate to have 3 top attorneys from O'Neill, Cannon, Hollman, DeJong, and Laing, based out of Milwaukee, Wisconsin, that specialize in employment law to provide help to all our listeners to understand their new obligations. Our first presenter will be Joe Gumina. Joe is a shareholder with a law firm and is the practice group's leader for the firm's labor and employment practices group. Joe is licensed to practice law in Illinois and Wisconsin. He has extensive experience representing management and vast array of employment and labor matters. Joe is also a seasoned litigator, having tried cases both in federal and state courts. Joe is a member of the Distinguished Trial Bar of the U.S. District Court for Northern District of Illinois and Chicago, and has been recognized as a super lawyer, which is not easy to get, and by Best Lawyers as a top-rated attorney representing management in labor and employment matters. Kelly Kuglitsch focuses her practice on the tax and labor law compliance aspects of employment benefits, including health plans, retirement plans, and related payroll matters. She helps employers to navigate this heavily regulated area with the goal of avoiding or minimizing risk and penalties. And Erica Reib focuses her practice on helping businesses navigate employment law issues, including leave and wages and hour concerns. Erica helps clients with policy and agreement drafting, day-to-day implementation, advising, litigation. Basically, guys, we brought you the best we could bring, and they are just amazing. And they're dedicating, and we really appreciate their helping us today with this important information. So, Joe, I'm going to turn it over to you, and thank you.
Thank you, Dr. Conway. I want to thank you for inviting Erica and Kelly and I to speak to everyone today. We're excited about doing this. We have been receiving a lot of questions from our clients, and we're learning just along with our clients as this is a brand new law that was enacted on March 18th of this year, just last week. And more questions are being raised as we as the Department of Labor releases more guidelines on exactly what that means. So as everyone knows, today we're going to be talking about what employers need to know about the Families First Coronavirus Response Act. It's the laws intended to provide relief to businesses and to employees because of the impact of COVID-19. And this act has some very specific and unique laws that many employers will now have to comply with, that they weren't necessarily used to complying with or had to comply with at all while they before COVID-19 appeared. So before we get going, I'd like to just get through the legal part of the presentation and the disclaimers. I want everyone to know that we're talking about a federal law. Again, we're going to be discussing the Families First Coronavirus Response Act and a couple of the other acts that are embedded within that law. The information provided regarding the FFCRA, again, the Families First Coronavirus Response Act, is for general information purposes only. It does not constitute legal or professional advice. No participant should act on the basis of any material contained in the webinar without first obtaining proper legal or other professional advice specific to their situation and applicable to the jurisdiction where your business is located. Moreover, you should be aware that applicable state or local law may impose different or additional obligations upon you as an employer than what is discussed during this webinar. So also check applicable state or local law before deciding on a course of action. Finally, participants understand that by participating in this webinar, there is no attorney-client relationship created by and between any of the participants and any of the presenters or their law firm. So let's talk about today's agenda, what we're going to cover. And we're going to move quick. We only have an hour to speak. We each are going to get 15 minutes to speak. I am first going to present on the Emergency Family and Medical Leave Expansion Act. We'll talk about what that act entails and what obligation it imposes upon you as an employer. And then Erica then will talk about the Emergency Paid Sick Leave Act. And as many of you heard about, that this is a brand new law with regards to providing employees impacted by COVID-19 with up to 80 hours of paid sick leave. And Erica will discuss the intricacies of that law. And then finally, Kelly will speak on the tax and employee benefit issues that have been impacted by these new laws. And also we'll talk about the key provisions in the CARES Act that Congress just recently passed. And then finally, as I indicated, we'll leave 15 minutes at the end for questions and answers because I know that many of you will have questions and will be uncertain as to how all these laws work in the real world. And we'll try to help you out with that. So first, let's talk about the Emergency Family Medical and Leave Expansion Act. So what is it? It's a federal statute enforced by the Department of Labor. Well, I guess first of all, I should start off in saying, I know most of you do not have 50 or more employees. And before COVID-19 impacted the United States, we had a law, or we have a law called the Family Medical Leave Act. Maybe some of you are familiar with it, but only large employers were required to comply with the, and I'll call it the FMLA, which is commonly referred to. It only applied to large employers. And I know many of you are not large employers, have less than 50 employees, and have absolutely no experience dealing with the FMLA. So what I'm going to do is just give you a quick primer in 2 or 3 minutes of what is the FMLA. So when we talk about the FMLA Expansion Act, which Congress just passed, we're going to have some background to where this takes us. So under the FMLA as it existed prior to the impact of COVID-19, it only covered those entities, a covered employer who employed 50 or more employees during 20 or more calendar work weeks, either in the current or preceding year. So for example, if you're an employer and you have, let's say you have 48 employees today, but back in 2019, for 20 or more calendar work weeks, you had 60 employees, you would be a covered employer for all calendar year 2020. It also allows eligible employees of covered employers to take up to 12 weeks of unpaid leave. It's an unpaid leave provision without loss of insurance or employment because of the employee's own serious health condition or that of a covered family member. And who is an eligible employee under the FMLA, again, as it existed prior to the impact of COVID-19? To be an eligible employee, you have to be employed by a covered employer, as we just discussed. You have to be employed for at least 12 months, and you must have worked for at least 1,250 hours in the previous 12 months, and be employed at a work site where 50 or more employees are employed by the employer within a 75-mile radius of that work site. So that who was eligible for FMLA leave for a serious health condition, again, you get up to 12 weeks of unpaid leave. Now, all those rules that I just explained to you, you can throw them out the window. They don't apply to the Emergencies Family and Medical Leave Expansion Act. And it's a brand new law, offers some brand new concepts relative to employees' rights and employers' obligations to provide unpaid and paid leave under this act. This law was signed into law by President Trump on March 18th, 2020. Its effective date is April 1st, which is next week, Wednesday. So come next week, Wednesday, all employers with fewer than 500 employees will be obligated to comply with this law. And we'll talk about certain exemptions for some smaller employers and certain other types of employers later on in the presentation. This law is only in effect till December 31st, 2020. So it only applies to employees who want to utilize leave for the purposes that this law allows for leave between that time period, that being April 1st and December 31st, or the end of the year. Right now, it does not look like the law will be extended beyond the first of the year, but you never know. Congress can always amend the law to extend it. So we'll have to see how things develop. So let's talk about, in basic terms, what the law provides, what the FMLA Expansion Act provides. Again, from April 1st through December 31st, private sector employers with fewer than 500 employees and certain public sector employers with at least one employee must provide eligible employees up to 12 weeks of leave for a qualifying need related to a public emergency, with 10 out of those 12 weeks to be given to the employee as paid leave at 2/3 of the employee's regular rate. Now, just in that small slide, I've thrown a lot of terms at you. We have employer, we have qualifying need related to a public emergency, we have paid leave, we have 2/3 of an employee's regular rate. I will, in the following slides, try to explain what all these terms mean and how they apply to you, especially if you are a small employer. So let's talk about, we'll cover who is a covered employer under the FMLA Expansion Act. Again, as I indicated before, the FMLA Expansion Act expands who is a covered employer, and based on the laws that previously existed. It expands who is an eligible employee, and again, as it existed prior to the impact of COVID-19. And it also expands the reason that an employee can take a leave. And again, that is an employee can take a leave under the Expansion Act for what's deemed or defined as a qualifying need related to a public health emergency. Again, in a few minutes, we'll explain what that means. So who's a covered employer? Again, it's private sector employers with fewer than 500 employees. This means that this portion of the FMLA applies to small employers. That is, employers with fewer than 50 employees. Again, affecting employers or small employers who've had no experience dealing with or how to administer leave under the Family Medical Leave Act. So within less than a week's time, employers, small employers, again, those with fewer than 50 employees, will now have to learn, understand the rights and obligations under the FMLA Expansion Act, and know how to apply that and provide those rights to their employees. So I know small employers, again, have a lot of questions about how it applies to them, how to administer that. Again, hopefully we can provide you that information. Now, there are possible exemptions. It does not cover every employer. There are certain healthcare providers and emergency responders who may be excluded from the Act. However, that's all the law provides for right now. Congress delegated to the Department of Labor, who is the administrative agency who will be responsible for administering and enforcing this new law. They've delegated to them to issue guidelines in interpretation of this specific provision. So they will define who is a healthcare provider who's excluded from the Act. They have not yet done that. However, if you look at the FMLA, again, as it existed prior to COVID-19, it does define a healthcare provider as including chiropractors. So it's possible that chiropractors could be excluded from the obligations of the Act. At this point, sitting here today, at this moment in time, I can't tell you one way or the other whether chiropractors will be excluded or not. So at this point in time, I would assume that chiropractors will be included, but we'll have to see as to whether they will be considered that certain healthcare providers who will be exempt or excluded. Also, small employers will be exempt from the requirements of providing the expanded leave when the imposition providing such leave would jeopardize the viability of the business as a going concern. I'm going to tell you right now that is a huge standard for small employers to try to meet, and basically what you'll have to prove, given the current structure of the law, the way that it is stated in the law, is that you will basically have to say that you will go out of business if you provide one of your employees with the paid leave under the Expansion Act. So let's talk about who's an eligible employee. An eligible employee will be eligible for leave under the Expansion Act if that employee has worked for you at least 30 calendar days before the request for the leave is made by the employee. There's no minimum hours requirements. Not like we talked about having worked 1,250 hours in the preceding 12 months. That doesn't apply. So if you have an employee that's on your payroll that's worked for you for 30 calendar days and it's only worked 8 hours in that 30 calendar days, they're going to be covered and they're going to be entitled to leave under this Act. Now, why can employees take leave under the Expansion Act? It's for a qualifying need related to a public health emergency. And what is a public health emergency? It's basically because of the impact of COVID-19, which has been declared by both the national government and I believe almost every state in the nation as a national or state emergency. So what does a qualifying need mean? So if you have an employee who is unable to work or telework, which means to work from home or from another remote location, due to the need for the leave to care for the son or daughter of that employee who's under 18 years of age, because the school or place of care has been closed, or the employee's child care provider for such child is unavailable due to the impact of COVID-19. Now let's talk about the structure of the Expansion Act leave. The first 10 days of leave, or the first 2 weeks, you look at a week as being 5 working days, is unpaid. And Erica will talk about the Sick Leave Act provision and how that can be used at this period in time for if an employee takes unpaid leave. Now, an employee can, if they qualify for leave under the Expansion Act, when they take it in the first 2 weeks, the first 10 days are unpaid, they can substitute any available leave that they have available. So if they have vacation time, they can take vacation time during this time. If you have a sick leave policy and provide for paid sick leave under your own workplace policy, they can substitute and use that leave. If they require leave for more than a 2 week period, again, they get up to 12 weeks of leave, 10 weeks of that has to be paid. And it's paid at an amount that's not less than 2/3 of the employee's regular rate of pay. So it must also include overtime hours. So it must pay the employee all hours that he or she that's normally scheduled to work. So even if that's more than 40 hours a week. However, there's some good news, because I know a lot of employers are strapped for cash, and cash flow is very important at this point in time for all businesses. That the paid leave is capped at $200 per day, or $10,000 in the aggregate over the 10-week period per employee. Now, what is an employee's regular rate of pay? This is the complicated topics, and it actually is beyond the scope of this presentation, but I'll just tell you simply, it includes all forms of compensation, and it's calculated basically as follows. The regular rate equals total compensation in a work week divided by the total hours worked in a work week. And it's just not the hourly wage or salary that you may pay an employee. It includes all forms of compensation. So during that time period in which you're trying to calculate what is the regular rate, if your employee gets any types of bonuses, non-discretionary bonuses during that time period, you have to include that bonus amount in the amount of compensation they receive. So we'll actually, if you pay somebody $10 an hour and during the look back period in which you're figuring out the regular rate, they also get a $1,000 bonus in that time period. Well, you got to factor in that $1,000 bonus, and it's going to increase the regular rate. Basically, it's an effective rate. It's not going to be $10. It's not going to be the $10 hourly rate. It's going to be something higher than that. The Department of Labor says you have to go back over a 6-month period of time to determine the regular rate, to actually figure out what that means for each employee. Also, you have to understand there's restoration rights. So if an employee takes leave under the Expansion Act, when they're done with that leave, they have the right to be restored to their same position at the same terms and benefits of employment that they enjoyed before they took the leave. However, there's an exception for small employers. Employers with fewer than 25 employees. That means if you have employees you employ 1 to 24 employees, you do not have to restore the employee to his or her previous position if, and here's the requirements, if the position no longer exists due to economic changes because of COVID-19, that then you made an effort to restore the employee to alternative equivalent position if one exists. And if an equivalent position is not available, then for a 1-year period beginning on the earlier of the date in which the leave concludes, or the date that is 12 weeks after the date on which the expansion leave first commences, the employer makes a reasonable effort to contact the employee within that 1-year period and try to restore them to equivalent position, and the employee declines that offer, the employer is exempt or excused from restoring the employee back to their previous position. Also, you should be aware that you will have posting notice requirements. And here's the official notice issued by the U.S. Department of Labor that all employers with fewer than 500 employees will have to post in conspicuous places at their place of work. If your employees are not at work and they're teleworking already, then you'll either have to email this notice to them, or if you have an internet site that's accessible just to your employees, you have to post it on that site and make your employees aware that this notice exists. So, and to find that poster, I know a lot of you will say, well, where can I get that poster? Here's the website or web address at the Department of Labor where you can find this poster, download it, and print it and post it at your place of business. And with that, I will turn it over to Erica Reib, who will speak about the Emergency Paid Sick Leave Act.
Hi, everybody. So I'm going to talk a little bit about the Emergency Paid Sick Leave Act, and I've been trying to keep up with reading some of the chat messages that I can see, and so I'll try to address those kind of as I go through this. I know there's a lot of concern about whether this applies to employees who are laid off. The Department of Labor has issued some Q&As, and they have said that this does not apply to employees who have already neither the FMLA expansion or the expanded paid sick leave. Neither of those will apply to employees who have already been laid off, or if they are laid off while they're taking sick leave. You cannot, lay them off because they're taking that kind of leave, but it will not apply to them if they're not actively working. It's really made to be used, or it's intended to be used if the employee is scheduled to work, there's work available to them, and they cannot work because of a COVID-19 related sickness, or they're caring for somebody. So talking about the emergency paid leave, again, it will be effective April 1st of 2020 and will run through the end of this year. It is not retroactive. So if you have had employees who have taken leave related to COVID-19 prior to April 1st, it does not count towards this 80-hour allotment that they will get under the new federal law. And there is no carryover. So if they don't use their 80 hours by the end of the year, they're not going to be able to take that leave into 2021. And again, they're not paid out any leave, even if you would have a policy that you pay out vacation.
Erica, we lost your audio. Everyone, please stand by. We have lost one of our speakers, so everybody just please stand by for just a second. Dr. Conway, can you or Joe, one of y'all, message and let?
Yep, I'll be working on it right now.
Okay.
And maybe we can switch to Kelly and then come back to Erica too.
Hi, Joe and Kelly. So we're going to pick up. This is what happens when you present live. You experience some technical difficulties. Thank you, Kelly.
Kelly, you turn your mic on.
Thank you. Okay, hello everyone. While we wait for Erica to return, I will just proceed with some employee benefits and tax credit provisions to keep in mind at this time. I specialize, my focus is a little bit different than Joe and Erica's. I specialize in employee benefits, payroll and tax compliance matters. And so I'm going to be talking about some provisions of the law that are already in effect that apply to matters. I will also talk about some new legal provisions relating to 401ks and the employer tax credit relate to the laws that Joe and Erica have been discussing. Looks like Erica's back. I'm going to switch to employee benefits, Erica, and we'll get to you when I finish up in a few minutes here. I know that for many of you out there, this is, of course, for all of us, it's a stressful time. You're making decisions about your business and assessing financial planning. I would just encourage each and every one of you, to the extent that you do offer any employee benefit plans, health plan or retirement plan, to not forget about those plans as you are making decisions. If you do offer benefit plans, you know that these can be a big expense. It's a big spend for employers. So at a time when there's likely going to be strain in your business, you just want to be mindful that you stay in compliance with the many laws that apply to health and retirement plans and communicate your decisions as well. So one of the tricky things about employee benefit plans generally is that the terms of the plans can vary by employer. You may have adopted your own special provisions. There can also be some variations by state. And so it's really hard to give one size fits all advice. And that's why you really need to check your benefit plan documents. At this time, I would encourage you to check the eligibility provisions. Some kinds of leave under some plans will not cause someone to lose eligibility. Also, don't assume that someone loses plan eligibility immediately upon termination of employment. If you might have to terminate somebody's, sometimes that extends to the end of the month. So you really need to check your document. A lot of health plan policies require that to be covered, an employee has to work 30 hours a week. So if you have people that are going to be working less than that now, you need to sort of carefully consider whether you need to offer them COBRA if they're losing eligibility because of a reduction in hours. And that plays together, though, with if they will be taking FMLA paid leave or unpaid leave under these new laws. The existing FMLA requirement to continue benefit coverage is not going away. That continues. So it's kind of a lot to look at there, but you would just want to make sure you're applying the eligibility provisions properly. If you are subject to the Affordable Care Act, there could be some additional issues there. That's going to apply mostly to employers of 50 or more, so I'm not going to spend a lot of time on that, although we can take questions if you have any. I've broken my health plan comments down into kind of three big categories. One, are you going to keep offering your benefit plan, which is, of course, ideal for business continuity and returning back to normal when all of this is over? And are you going to be able to keep at least some of your employees employed? If you do that and you find that you've now got some people at home, maybe not being paid for an interim period, think through the mechanics of how they are going to continue to pay their portion of any employer premium contribution. In normal times, it's common for someone at home not being paid enough to pay the premiums out of their payroll deferrals to mail you a check. But right now, you need to think about, is someone going to be in the office to take the check? Are there any electronic payment provisions? Do you want to make a well-planned agreement with them now that you will pay the premiums for the time being and they will pay you back when they return? So those are all things to think about. Second, if you know you're going to be terminating some employees, be very aware of continuation coverage obligations. If you have 20 or more employees, you're going to be required under the federal COBRA continuation coverage to offer them to elect COBRA coverage under your plan. Alternately, be aware that if someone loses workplace coverage, they have a 60-day special enrollment period under the Affordable Care Act, healthcare.gov marketplace. And that's going to, for many people, be much more affordable than COBRA. Just be aware that that's a resource out there. If you don't have 20 employees, you may still be covered by a COBRA-like state continuation coverage law. Here in Wisconsin, that applies to employers of any size, and it requires notice be provided within 5 days. So I encourage you to get familiar with your state continuation coverage provisions. A third category. What if it's just going to be too expensive to continue offering your group health plan? You've got to be realistic. And if you can't pay the premiums, then the best thing to do is to kind of shut it off, end that cost, don't incur any additional costs. Just know that if you do terminate a plan, there is no plan under which COBRA can be offered. Again, there could be a state right, a conversion right, under which people can convert to an individual policy. Your employees who are terminated do still have the Affordable Care Act healthcare marketplace available. Just lots of different ways to go, and so it warrants careful planning. Now I want to talk about the CARES Act, which has been approved by the Senate. It's expected to be voted on by the House today and signed immediately. So this is the third round of stimulus coming through to assist employers and individuals in light of the pandemic. It's a huge stimulus bill. It's larger by many factors than the stimulus bill offered in early 2009 as a result of the Great Recession. There are a lot of aspects to it, but what I'm focusing on today, is good to know about are some increased participant access to their 401k account funds. So if you offer a 401k, you may have employees suddenly interested in taking a hardship distribution if your plan permits that. And if it doesn't, you could amend it to permit that. Or taking a plan loan. Typically, if you take a hardship distribution and you're not age 59 and a half, you're going to pay a 10% early penalty, 10% tax. That is waived under the CARES Act, which we expect to be enacted very shortly. So it's no penalty distributions in all of 2020. These provisions go through the end of this year. The amount of plan loans that participants can take from a 401k has now increased from a maximum of $50,000, and that was they can only borrow up to half of their account, to $100,000 if they have that much, without regard to the percentage that represents in their account. If they have $100,001, they can take $100,000. Normally, there's also some loosened provisions for loan repayment. Normally, if someone does not make a plan loan repayment for more than 3 months, the entire loan balance is deemed to be taxable. Under the CARES Act, anyone taking a loan between the day it's enacted and the end of this year will have 3 years to repay their plan loan. It can be in 1 or more payments, but that's a relief for the employees taking plan loans. And finally, the required minimum distribution rules require people age 70 and a half or greater to take certain amounts out of their plan every year or their IRA. And this applies to IRAs as well, this new relief. There's a concern that because the required minimum distributions are valued at the end of last year, people taking them out now would really be suffering the investment losses that have happened because of the marketplace. So there's a 1-year delay on taking those under the new law. I'll just quickly get through the employer payroll credit provisions that are in the Families First Coronavirus Response Act. This is intended to help employers fund and pay for the expanded paid sick leave and FMLA leave. It also is going to be increased by health plan expenses, but we don't have a lot of guidance on that yet. But just know that if you decide to pay for some employee premiums, as long as you pay for it and not them, you can also get the credits for those payments. The way the credits are going to work is they're going to be offset against the employer portion of Social Security employment taxes, the 6.2%. We're waiting details, but we believe you'll claim it on the quarterly Form 941. And then there's under the CARES Act, which we're waiting for any minute, it's going to delay your deadline on actually paying payroll taxes on any 2020 wages. Half of the amount owed will be paid at the end of next year, 2021, and the second half won't be paid until 2020, the end of 2022. This is my last slide, then we'll go back to Erica. I just want to give you some examples that the IRS has shared about how these employer tax credits will work. So we'll just walk through these. Let's say that you pay $5,000 in covering the cost of employee sick leave and or FMLA expanded leave. But otherwise you owe $8,000 in your regular employment taxes. With this offset provision, you get to dollar for dollar reduce your costs for the leave payments or the health plan payments. And now you're going to only owe $3,000 of those employment taxes. Conversely, if you pay more in the leave expenses or the health plan expenses than you owe in payroll tax credits, like if you pay out $10,000, but you only owe $8,000 in taxes, you will get the excess amount as a refund, and you can request to be paid that on an accelerated basis. So lots more detail that we're waiting on, but that's the mechanics of how it will work. Thank you. I'll hand it over to Erica.
Hi, I'm so sorry about falling off there, the joys of working from home. But I think I have a secure internet connection now, so hopefully everybody can hear me. And I'm just trying to go back through the slides, which is kind of slow. I've seen some questions coming in, and I don't exactly know when I got cut off, but I was talking, oh, there's my first slide, about the fact that it doesn't apply retroactive. So I saw someone ask a question about, my employee was out, in March already. Can they use the 80 hours towards that? No, they can't. It will have to start April 1st. They will get kind of a new 80 hours of potential paid sick leave. I know somebody else had a question about the the date that this will be enacted. When the president signed it, he said that there was up to 15 days. So everybody had kind of thought that that was going to be April 2nd was the 15 days. When the Department of Labor published their regulations on the act, they said it will be effective April 1st. So that is the date that it will need to go out. So I think I was on, at least when I believe I got cut off, I was on the fact that all employees are eligible from day one. There's no 30-day requirement like there is under the expanded FMLA, and there is no, if you have a kind of your normal policy doesn't, they don't get vacation for the first 30 days or whatever, that will not apply. This applies from day one. Make sure to post the notice that I know somebody asked a question of what you're proactively have to tell your employees. You do have to post the notice. And my slide says when it's available because I put these slides together before the DOL had come out with them, but that link's in Joe's slide and in the files. So reasons for leave. And I know somebody asked a question about, if people kind of self-quarantine, are they going to be able to use the leave for that? And the answer to that is no. So there's 6 reasons for leave is, subject to a federal, state, or local quarantine or isolation order. There's a little bit of lack of clarity at the moment about whether or not stay-at-home orders apply to that. My opinion, and I think pretty well supported by definition, other statutes definitions of quarantine or isolation, that a state stay-at-home order would not apply. Additionally, if your business is truly closed, you would not have to provide this leave, because if the business is closed either before April 1st or after April 1st, you don't have to offer this leave. The second reason is if they have been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Some employees are who have immune disorders or increased susceptibility to COVID-19 have been advised by their healthcare providers to stay at home. So they could use their 2 weeks for that. If they are experiencing symptoms of COVID-19 and seeking a medical diagnosis, again, this isn't self-quarantining, this isn't, I think I have symptoms, it's that they are, seeking a medical diagnosis. And for both of those and a couple related to care for people who are also either experiencing symptoms or are self-quarantined, you can ask for a doctor's note for that, similar to how you would for a normal doctor's note. The third is caring for an individual who's subject to quarantine or isolation order. The next one is caring for an employee's child who, if their place of their school or daycare are closed. This is again why you would use the EFML, the expanded FMLA, what employees can use that for. And this would provide kind of those first 2 weeks of notice or of pay under those. And then the last is kind of a catch-all is if they're experiencing other substantially similar conditions as specified by the Secretary of Health and Human Services. That at this point isn't really applicable. I think that's meant to apply if there are kind of mutations of this and things change and need additional expanded leave. So the pay under the expanded the Emergency Paid Sick Leave Act is that they are entitled to their leave based on their normal wage, including overtime, commissions, tips, and piece rates. So if you have, I know somebody asked a question about, what if people are paid on collections only? And that would be, you'd have to kind of, over the last 6 months, look at what their kind of average wage was and use that for your 2 weeks. It is capped at $511 per day for quarantine or isolation, advised by a healthcare provider to self-quarantine, or if they're experiencing, that says accepting coronavirus symptoms, but it should say experiencing coronavirus symptoms. It is capped at $200 per day for employees who are taking care of someone else who has coronavirus symptoms. Some of the potential exemptions, like the expanded FMLA, employers under 50 may not have to provide this leave if it would jeopardize the business as a going concern. Again, I think that's going to be a pretty high bar, but at this point, the DOL is suggesting to document that, but don't send them anything else. But I think there is a risk to that if you cannot show that paying this would have jeopardized your business as a going concern, then you have potential liability to those employees who would have otherwise taken it. So then, and healthcare providers, as Joe talked about with the expanded FMLA, this will, healthcare providers may be exempt from this, including chiropractors, but we'll have to see kind of the physician extenders, your PAs and your nurse practitioners and other people that help you in the office may not be defined as healthcare providers and then would be eligible for this leave. Interactions with other leaves, if you have a paid sick or PTO policy, you cannot require that the employees use those first. They're eligible to use this leave first. It can be used in conjunction with the expanded FMLA for the closed schools and closed childcare. Again, that would apply to kind of those first 2 weeks, which under the EFMLA are not paid. And then the temporary non-enforcement, the Department of Labor has said that they will not enforce these policies for 30 days. Employers are acting reasonably and in good faith to try to comply with the law. The 30 days is from the date that the law was signed, so it actually only extends through April 17th. But again, this does not bar employees from bringing suits. So while the DOL, who handles these, could say, you acted in good faith and you have remedied that error and you're going to comply with it moving forward, an employee could still bring a suit. So that is kind of a very, truncated presentation of my slides, because I know there are a lot of questions and I think we want to try to get to them if we can. So I think we can bring, everybody's gonna come back online and we'll try to.
Yeah, thank you, Erica. That was very good information. Now we'll cover. I want to make you aware that if you have additional questions or after this presentation you want to learn more about the Families First Coronavirus Response Act and the laws that we just discussed, there is a website that the DOL has dedicated to all these issues, and here's the website address. So you go to www.dol.gov/coronavirus. It will take you to a web page that provides you all the information about these laws and how it affects both large and small employers. So now we have about 12 or 10 minutes to take some questions. We know that some questions have been proposed to us or given to us, and we'll try to answer them the best that we can. One person asked that they're confused about the start date for the 2 weeks of fully paid sick leave. That starts on April 1st. So if an employee requests leave beginning April 1st and they qualify for that leave, as Erica explained, they can take it beginning April 1st. We've had other questions about, well, what happens if either I close my business or I lay that employee off prior to April 1st? Then the answer is no, you do not have to provide that employee paid leave either under the Sick Leave, Emergency Sick Leave Act, Paid Sick Leave Act, or under the Expanded FMLA Act.
And to jump in on that, even if you end up closing your office after April 1st, if it's a full kind of office closure and that employee wouldn't be working, you would not have to continue to pay those benefits.
Correct. What you don't want to do is, once the employee exercises his or her rights to take either leave under the Expanded FMLA or paid leave, it'll be very difficult to lay them off without drawing a claim for retaliation. So you want to be very careful if, because of business circumstances, you can no longer employ this individual, laying him off can be very risky. And what you would have to show is that the layoff would have occurred even if the employee never decided to exercise their rights under either the expand FMLA right or the Paid Sick Leave Act. And Erica, did we lose you again? There you are. Are you with us?
Yes. I don't know what's happening to the internet at my house.
I'll just jump in on a question that I saw. I see someone has asked, what are we required to tell our employees about the new law and their benefits? So I'll address only the benefits side. And then Joe and Erica, you could jump in on the paid leave and FMLA provisions. On the benefits side, I want to stress that you want to be very careful to just communicate clearly. As far as I know, there's not a mandatory obligation to explain all of these new provisions to your employees, at least not under the current law. That could, whatever you do explain though, because you are a fiduciary of the plan with heightened legal responsibilities for correct representation of the facts, needs to be accurate. And so one thing I want to caution against is being optimistic. If you do see some closures or in your future, you know, as much as you may want to, try to avoid making grandiose promises like, oh, we'll cover you no matter what. Oh, you're not working 30 hours a week, that's fine, we'll cover you. Because under the federal law, the employer who made the promise to pay that coverage is going to be held to that promise, even if the insurer decides not to pay it because the people weren't actually eligible, weren't working, say, 30 hours a week. So I'm seeing and hearing a lot about our really short-term plans and frequent reassessments. You might want to say to your employees something like, we are going to keep the plan going for 2 weeks, or we're going to keep people employed for 2 weeks, and we're going to reassess. And sort of just keep things clear that way without overpromising.
I will say, while Kelly was talking, it came through my phone that the House has passed the expansion, the CARES Act. So that is expected to be signed by the president later today. I know that somebody is I'm just kind of reading through questions as they're coming in now, and somebody's asked if they lay off all staff on March 31st, then they would only have unemployment benefits until we rehire and reopen. That's correct. Yeah, if your whole office is closed, you do not have to provide pay under either the expanded FMLA or the Paid Sick Leave Act.
Another question that came in was, how do we pay associates if we don't pay them not only wage, but we pay them on a percentage of their collections. And the same formula applies. What you would have to do is take the commissions that they earn over go back a 6-month period, divided by the total number of hours worked, and figure out their regular rate using that formula, as long as that math equation doesn't equal less than the federal minimum wage rate.
Somebody also asked a question about whether this leave can be taken intermittently. Leave under certain, the leave for if a child's school or daycare is closed can be taken intermittently with the agreement of the employer. Again, the employer has to agree, although the DOL is encouraging employers to try to be flexible about this when possible. However, if it's for an employee's own sickness or they're caring for someone with COVID-19, that cannot be taken intermittently, because the point is to have them out of the workforce at that point and not be affecting people. I think a couple people have also asked about 1099 independent contractors. If they are not employees, this will not apply to them. I think this could lead to some additional litigation about kind of who is an employee and who is actually an independent contractor, because if they're not, they're not eligible for those benefits, and you wouldn't be eligible for the tax credit for a non-employee. But I think that independent contractors could look at this situation and say, I feel like I'm actually an employee and I should be treated as one. So that's a potential issue.
Another question that's come in, someone asked if I had been exposed and need to quarantine myself and then had to quarantine my staff, would they be entitled to the 2 weeks sick leave plan? I guess there's two issues there. I guess if you're the primary or the principal of the business and the business exists around your services, I guess you could take the position that you're closing your business. And under those circumstances, if you close it before April 1st, the paid leave provisions under the FMLA Expanded Act and the Emergency Paid Sick Leave Act would not apply. But assuming that this occurs on or after April 1st, if under these circumstances, if an employee is just self-quarantined because they have no symptoms and they're just concerned that they might have it or don't want to catch it, there's no entitlement to paid leave. However, if an employee believes that they might have it or suspects that they might have it, even if they don't have symptoms, but as long as they go and attempt to obtain a medical diagnosis during that time that they're seeking medical diagnosis, that is getting tested for COVID-19, for that time period, they would be entitled to paid leave. So you're going to have to address those situations on a case-by-case situation. And if employees believe that they've been exposed to COVID-19 and meet the testing requirements as established by the CDC or local health officials, then they should get tested. Stephen, do we have any more questions? I believe we've answered, I think, all of them.
I just sent one more over. Can you clarify, just so people don't misunderstand this, because there may be something in, if I close before April 1st and then I just restart back up in May, I don't have to follow all this.
So right now, the law is in place until December 31st of 2020. So if this is still, schools are still closed and employees or people are still experiencing coronavirus symptoms, you would still have to apply that leave, beginning whenever your office opens if people need it.
Right. There were just so many questions coming in where basically it appeared like if I do something before April 1st, then I don't have to deal with any of this. But that's
right.
Not true.
Correct. Yeah. Once you reopen, if you reopen in 2020, this would still. I know there's some questions coming in right now about the SBA loans. That is all part of the CARES Act that came out, was signed today. So I don't think we have all of the information about that at this point, unfortunately.
Yeah, and remember, as Erica indicated, that these benefits or these rates for paid leave, as Erica indicated, extend to the end of the year. And, a big question mark is, can we get control of the coronavirus now? And, will it dissipate and kind of, disappear from our society? But the question that nobody knows, I believe, is whether it will rebound or reappear come the fall or winter months near the end of the year. So you're going to have to be mindful that, if you decide to lay off employees now and we get to a point where we're having no new COVID-19 cases, that, it may reappear, and this is all going to apply later on in the year if we're in the same situation where we have employees who are getting ill or schools that are closing down because of COVID-19 and employees can't come to work or telework. They may be entitled to these paid leave rights under these laws.
To the extent they haven't capped them out already earlier this year.
To the extent that they haven't utilized them already, that's correct. So this is only entitled to a total of 12 weeks of paid leave, both under the expanded FMLA Act and under the Emergency Paid Sick Leave Act. Once they exhaust that, there's no additional paid leave available. However, if somebody is sick or is unable to work because they have contracted COVID-19 or have symptoms of COVID-19 and it otherwise qualifies as a serious health condition, and you're an employer with 50 or more employees, they will have their rights as they normally would for any other serious health condition under the Family Medical Leave Act.
So Chrissy, we're right at the bewitching hour, and there's a lot of questions piling in. So what we'll do is we'll just compile all those questions and then work through your system to get those information out to everybody. Is that how that would be handled?
Yes, and I've already started
I know, I'm looking
compiling
at them.
up.
They're all coming in, which we appreciate. What this shows is there's a lot of questions, there's a lot of stuff, because this has just not been something that's touched this level of employment before in our offices. So we truly appreciate you coming on today and taking all this complex stuff and trying to put it down to 15 minutes, which is almost impossible to do. But hopefully this was the starting point. And as we see some of these questions coming in, potentially maybe we can do a repeat, if you would be maybe willing to come back and help us again, because as you can see, there's just a lot of people not really understanding everything that's out there. So
absolutely. We would be happy to come back and maybe group the questions to into specific issues and address those issues that are coming up on a common basis amongst all the participants, so we can answer all the questions. And as Dr. Conway indicated, there's still a lot of unanswered questions, because the Department of Labor is still developing regulations and guidelines. So it's still very unclear of how these rules actually work and what exactly employees' rights are and exactly how they'll be enforced. So there's still more to come, and so that's why I gave you the website address to the Department of Labor. Continue to check that. You'll see updates from the Department of Labor and continue to review those updates, because you will get more information from the government on a lot of the questions that you have and the issues that you have related to your particular practice.
Great. Well, thank you all for participating in this. We truly appreciate your work today. Chrissy, I'll let you wrap it up.
Thank you.
Thank you.
Thank you all so much. And there are a lot of questions. I'm going to leave it open for another minute or two as our speakers are departing, so you can enter your questions. And just remember, if you are watching the recording and you submit a question, it will be emailed in and we will respond later. There's no need for any of y'all to send me your email address, because I have it, and request a copy of the Q&A afterward. Every single person who's registered either before today or after today to watch the webinar recording will get a copy of this Q&A. Please understand too that there's a lot of unknowns here. There's a lot of knowns. They're gonna answer this to the best of their ability. Some of this stuff could change in a week or two as more information is brought to light. And we will be continuing to have these webinars over the next couple of weeks, months, however long this takes, to make sure that you're getting the answers to the questions that you have. I want to thank all of you so much for being an amazing webinar attendees, because a lot of these topics of discussion were recommended by you. You asked me questions. What do I need to know about this? So you have more questions, send me more emails, and that's how we'll determine what we'll be talking about next week and in future weeks. Thank you again to all of our presenters today, and a very special thank you to my very dear friend, Dr. Steve Conway, who helps to make dreams come true, just like this webinar. So y'all have an amazing rest of your day and a fabulous week. You'll be getting an email from me between now and Monday with information about upcoming webinars, and I'll see y'all next week. Bye, everybody.
Thank you,
Hi,
everyone.
thank you.